This is Duke University.
And that way you can roam around.
Yeah, okay.
Good afternoon, everyone. Thank you for coming to today's event. It's a great pleasure and honor for me to introduce Judge Patrick Robinson, who has come to Duke for a brief visit. He's here today for this afternoon's lecture and also for a reception this afternoon at 4 p.m. In the balcony, I think, overlooking the Star Commons. So I hope if you haven't had a chance to talk to Judge Robinson today or thus far, then you'll be able to attend that reception. It's really wonderful to have someone of Judge Robinson's stature here who has done so many things in international law. He is currently a judge on the International Criminal Tribunal for the Former Yugoslavia, a tribunal in which he served as the president between 2008 and 2011. He currently serves on the appeals chamber. He has served in the trial chamber. He has also served on the appeals chamber of the International Criminal Tribunal for Rwanda. So he has deep and long experience in international criminal law, but in addition, he has held numerous other positions either with or on behalf of the Jamaican government, both within its own governmental structure and also representing Jamaica before the United Nations in treaty negotiations. He served as a member of the Inter-American Commission on Human Rights, and so is an expert in that area as well. I could go on in talking about the kinds of activities that he has done, but I think it's fair to say that among the speakers who have come to Duke Law over the past couple of years, Judge Robinson probably has more of an encyclopedic experience in public international law than almost anyone else I can think of. So today he's going to speak about his work at the ICTY, and he will then open it up to discussion and comments, so I will leave it to him. But please join me in giving a very warm welcome to Judge Patrick Robinson.
Thank you very much, Professor. Ladies and gentlemen, at the outset, let me express my gratitude for the invitation to come to this distinguished institution to speak to you about the contribution that my tribunal, that's the International Criminal Tribunal for Yugoslavia, where I have worked for the past 13 years, has made to the modern system of international criminal justice. For me, the visit is an historic one because it's my first visit to North Carolina and to Duke. And I want to express my gratitude to your colleague, Mr. Sean Spence, for extending the invitation to me. Having been introduced now to Duke, I have to say that hereafter, I will forever support the Blue Devils. In witness whereof, I don this headgear. That is in your encounters with the Tar Heels, you know. Unless they, of course, extend to me a similar invitation. Although the idea of an international criminal court or jurisdiction was raised from as far back as the period after World War I, the modern genesis of the topic was a proposal made in 1989 by Trinidad and Tobago at the General Assembly of the United Nations. This proposal, which was co-sponsored by the Caribbean countries, called for the establishment of an international criminal court with jurisdiction to try individuals and entities engaged in illicit trafficking of narcotic drugs across international frontiers, as well as other international criminal activities. The proposal was the initiative of the eminent Caribbean statesman, A.N.R. Robinson, who was at that time the Prime Minister of Trinidad and Tobago. The item was referred to the International Law Commission. I was then Jamaica's representative to the 6th Legal Committee of the United Nations. And when I was elected to the International Law Commission in 1991, the ambassador of Trinidad and Tobago to the United Nations specifically asked me to keep a watchful eye on the drafting of the ICC statute by the Commission. And to that end, I made sure that I was a member of the working group entrusted with that task, which was completed in a relatively short time. When the item was introduced in 1989 by Trinidad and Tobago, the reception in the 6th Committee and the General Assembly was lukewarm. But when the Yugoslavia conflict broke out in 1991, the Europeans came aboard and pressed for the establishment of an International Criminal Court. In the result, the Statute of the International Criminal Tribunal for the former Yugoslavia was adopted in 1993, establishing the tribunal to try the most serious violations of international humanitarian law in the former Yugoslavia. That statute and the tribunal's work influenced the adoption of the 1998 Rome Statute for the International Criminal Court. As a proud Caribbean national, whenever it is appropriate, I seize the opportunity to highlight the seminal role that a small Caribbean country played in initiating the process that led to work on an international criminal jurisdiction and ultimately to the establishment of the ICC. This role is not widely known, and in the respect of those who are aware of it, not sufficiently acknowledged. I also make the point to demonstrate the historic connection between the tribunal and the ICC. In this presentation, I propose to focus on the contribution of the tribunal to the development of a corpus of law at both the substantive and procedural level, which has strengthened international criminal justice. Prior to the establishment of the tribunal in 1993, the only other international criminal tribunals to have been established were the Nuremberg Tribunal and the Tokyo Tribunal after the Second World War. The tribunal has built on the work of those two tribunals and has been the main contributor to the growth of a modern system of international criminal justice. In the first part of the presentation, I'm addressing now the contributions to substantive law. And the first area I want to deal with is the fight against impunity. A signal contribution of the tribunal to the development of international criminal justice is undoubtedly the dent that it has made in the culture of impunity for war crimes. The tribunal's impact on impunity becomes immediately apparent when one considers that every single one of the 161 persons indicted at the tribunal has been arrested. It is true that the first indictment having been issued in 1994, this has taken some time, 17 years, with the last set of accused, Karadzic, Mladic, and Hadzic, arrested in the last 4 years. Nonetheless, it is a fantastic achievement and one that reflects the resolve and determination of the tribunal, in particular its prosecutor, as well as the United Nations and the international community at large. The tribunal has concluded proceedings against 126 accused persons, and there are ongoing proceedings in respect of 35 accused. But in my view, the clearest sign of the impact of the tribunal on the culture of impunity is the trials that have taken place of a wide range of actors involved in the commission of war crimes. The tribunal has built on the foundation of individual criminal responsibility laid by the Nuremberg trials. and its work has made it abundantly clear that heads of states or governments cannot hide behind the doctrine of state responsibility to avoid individual responsibility. The statute provides that persons who commit breaches of international humanitarian law, such as genocide, war crimes, and crimes against humanity, are individually responsible for those crimes. The statute explicitly asserts that the official position of any accused person, whether as head of state or government, or as a responsible government official, shall not relieve such person of criminal responsibility, nor mitigate punishment. And the tribunal has prosecuted persons across the entire spectrum of national life, from Dusko Tadic, a prison guard, to Milan Lukic, a leader of a paramilitary group, to Ratko Mladic, a former commander of the Bosnian Serb army, to Radovan Karadzic, former president of the Republika Srpska, and Slobodan Milosevic, the former president of the Federal Republic of Yugoslavia. But the tribunal's legacy is not just that these trials have taken place, but that the trials have been fair. No kudos would attach to the tribunal for its fight against impunity if its trials were not seen to be fair, because an accused is entitled to a fair trial, and that right is a peremptory norm of general international law, that is, jus cogens. Today, individual criminal responsibility is the basis for the jurisdiction of all international criminal courts. The International Criminal Tribunal for Rwanda, the tribunal's sister court, the Special Court for Sierra Leone, the extraordinary chambers in courts of Cambodia, and the International Criminal Court. An outcome that is due in no small measure to the template established by the tribunal. An essential feature of an international rule of law is that states, individuals, and organizations are equally accountable for the commission of international wrongs. To the extent that the tribunal has arrested and tried persons from all sectors of national life, from foot soldiers to heads of government, it has helped to affirm the international rule of law. In that regard, its legacy can be felt in the emerging global culture of accountability, in the development of which the United Nations has an active role in areas such as its UN peacekeeping responsibilities and the work of its special representatives. Now, of course, it was never intended that the tribunal should try all the crimes committed in the Yugoslav conflict. That was neither feasible nor desirable. In 2003, the Security Council mandated the tribunal to transfer the cases against lower and mid-level indictees to national jurisdictions. The tribunal has done so, and those trials have taken place. Additionally, the national courts in the countries of the former Yugoslavia are conducting trials in respect of the multitude of crimes that were committed in the Yugoslav conflict. Thus, the tribunal's fight against impunity has been complemented by the work of the national courts of the countries of the former Yugoslavia. And in 2003, the Security Council mandated the tribunal to undertake capacity building in those countries to ensure that national courts were equal to the task of conducting those trials. The tribunal has assiduously implemented that mandate. Moreover, one feature of the tribunal's work that distinguishes it from the Nuremberg and Tokyo tribunals is that the charge of victor's justice, that's the trial of the losers by the victors, laid against those tribunals cannot be fairly leveled against this tribunal. I have heard such a charge against the ICTY, but in my view, it is unfounded. For unlike the Nuremberg and the Tokyo tribunals. The ICTY was not established by the victors in a conflict. The ICTY is an international tribunal established by the United Nations pursuant to the powers of the Security Council under Chapter 7 of the UN Charter. Moreover, again, unlike the Nuremberg and Tokyo tribunals, indictments have not been laid against one set of people who could be classified as losers. Rather, trials at the ICTY, the ICTY, have taken place of accused persons who are Serbs, who are Bosnian Muslims, Croats, Albanians, and Macedonians. The second area I want to deal with now in relation to contribution to substantive law is the elucidation of the elements of the major war crimes. Following the Nuremberg and Tokyo trials, international criminal law had, by and large, been dormant. The ICTY inherited an underdeveloped body of law, and its work has served to give force to international criminal justice by defining and clarifying the scope and elements of the core crimes of genocide, crimes against humanity, and war crimes. For example, the tribunal's case law has focused on the widespread and systematic requirement for crimes against humanity and the distinction between the crimes of genocide and persecution. Another example is the Kunerach decision, in which the tribunal departed from the public official requirement in the United Nations Convention Against Torture. The tribunal held that for purposes of international humanitarian law, it would rely on the customary international law definition of torture, and in that regard it found that the crime of torture was not confined to acts committed by public officials. And the tribunal was the first international body to hold that torture was a crime under customary international law and proscribed by Yugoslavians. The third area now is the advancement and enforcement of human rights law. There is scarcely a judgment or interlocutory decision of the tribunal in which the human rights of the accused, as well as the humanitarian interest of persons affected by war crimes, are not addressed. With regard to the first, the UN Secretary General, in his report attached to the Security Council resolution establishing the tribunal, stated that the tribunal must respect the internationally recognized rights of the accused, and in particular, those set out in Article 14 of the International Covenant on Civil and Political Rights. The tribunal's case law is replete with decisions that turn on the interpretation and application of those rights. For example, the right to self-representation was an important factor in the Milosevic trial. With regard to the humanitarian interest of persons affected by war crimes, the tribunal has been the most prominent actor since World War II in giving effect to what Judge Theodore Meron has called the humanization of the law of war. Judge Meron, by the way, is the current president of the ICTY. One example of this has been the tribunal's uniform and consistent application of the prohibition in international humanitarian law of the killing of civilians and the use of indiscriminate force causing civilian casualties. This prohibition is a principle of very long standing and must now be regarded as jus cogens, that is a peremptory norm of general international law from which no derogation is permitted. It is binding on all states, all international organizations, including the Security Council, and all persons. An important contribution by the tribunal in the area of human rights is its gender jurisprudence. Both the tribunal and the Rwanda Tribunal, that's the ICTR, have done seminal work in this area. Although the Nuremberg and Tokyo tribunals received a fair amount of evidence of sexual offenses against women, their judgments did not focus much on those crimes. In the result, it was left to the ICTY and the ICTR to develop the law in this area. Rape is explicitly identified as a crime against humanity in the statute of both tribunals, and sexual violence has been prosecuted as a form of genocide, crime against humanity, and war crime. In the Kunorach case, the tribunal found that rape was a crime under customary international law and that there was no requirement to prove resistance on the part of the victim, nor that the victim's lack of consent resulted from force or the threat of force. That could be inferred from the circumstances. At the procedural and evidentiary level, the tribunal has removed many of the obstacles traditionally found in domestic legal systems that make it difficult to secure convictions of persons for sexual offenses. Thus, no corroboration of the victim's testimony is required, and prior sexual conduct of the victim is not admitted into evidence. Can I just pause there to say that I was a prosecutor in Jamaica for 3 years, and I speak from first-hand knowledge of the difficulty of securing a conviction for rape, because in our law, as it was in the United Kingdom, you had to have corroboration, which was defined as some evidence independent of the complainant, which goes to prove that the offense was committed. But at the tribunal, no corroboration of the victim's testimony is required, and prior sexual conduct of the victim is not admitted into evidence. On a wider level, an important legacy of the tribunal is that it has spurred national courts to bring to justice those who commit violations of international humanitarian law, and its work has served to reinforce the application of human rights law in an armed conflict. You will see that I have omitted something, and I will explain to you at the end why I have. I have another section as part of the contribution to substantive law, and that is the application of customary international law. But it's a very difficult area, customary international law, and I'm not sure that everyone here is a law student. So if you wish to ask about it, you can, but I decided not to speak to it today. So let me turn now to the tribunal's contribution to procedural and evidentiary law. Procedural and evidentiary law subserves substantive law. It is the oil lubricating the wheels of substantive law. No matter how strong and well-developed substantive law is, its wheels will not turn without the foundational support of a facilitating set of procedural and evidentiary rules. And that certainly has been the experience of the tribunal, which found that it has had to amend its rules of procedure and evidence 48 times. Many of those amendments designed to ensure that its trials of persons charged with a serious breach of international humanitarian law would not be unduly prolonged. The main difference between the trials at Nuremberg and those at the tribunal is the sheer volume of evidence that is marshaled by the prosecution at the tribunal. But the factor that best explains the difference in duration of trials, and in Nuremberg the trial lasted 10 months, is that in Nuremberg the prosecution was able to rely on the very efficient record keeping of the Germans. Documentary evidence, not live testimony, was therefore the mainstay of the prosecution's case in Nuremberg. The Nuremberg trial had 33 prosecution witnesses, 61 defense witnesses, in addition to 19 of the defendants who testified. In contrast, trials at the tribunal have hundreds of witnesses and voluminous documentary evidence. For example, in the Perlich case, which is a multi-accused case, 6 accused, over 9,500 exhibits were tendered. At the time when the Milosevic trial was terminated, the accused had called 50 witnesses, in addition to the 352 prosecution witnesses. So from relatively early in its life, the tribunal faced criticism from the United Nations and the international community for the length of its proceedings, which are very expensive. For example, the biennial budget for 2008-2009 was $342 million with a staff of 1,097. Now you know the tribunal is downsizing and the staff is or will be reduced. And the current budget for the present biennium is $250 million with a staff of 869. Did I say first 342 million or 342,000? It should be 342 million. Not a little difference. The tribunal has therefore had to develop procedures to expedite its proceedings, but in doing so, it has had to ensure that the rights of the accused are not infringed. And in my view, the measures that the tribunal has developed constitute a major contribution to international criminal justice. The ICTY has a feature that is relatively unusual for a court. It is empowered through its judges in plenary to draft and amend the rules of procedure and evidence. And the tribunal has not been shy to exercise this quasi-legislative power and has, as I have already mentioned, amended its rules of procedure and evidence 48 times. Many of these amendments relating to measures to expedite trial proceedings. The tribunal's rulemaking function is very far-reaching. And in my view, many of the amendments deal with issues which have such substantive implications that they could only be called procedural in a very formal sense. Certainly, in most domestic jurisdictions, where judges are given a rule-making power, they would not be competent to make such rules. In those jurisdictions, that would be a parliamentary legislative function. Significantly, the Security Council, in establishing the tribunal, left it to the judges to draft and amend its rules of procedure and evidence. Now, the position at the International Criminal Court is different because there the Assembly of States Parties is involved in the drafting and amendment of the rules of procedure. Now, in devising these measures, the tribunal has had to ensure that greater efficiency was not achieved at the expense of fairness. And in that exercise, it has had to contend with, to confront, to come to grips with its peculiar system of law. The tribunal's trial procedures are basically common law adversarial, as can be seen by the following features. There is an independent prosecutor and an accused. In the middle is the trial chamber, comprised of 3 judges. And importantly, the collection of evidence is in the hands of the parties. On that basis then, in principle, the system would appear to be party-driven, unlike that which obtains in civil law inquisitorial jurisdictions, where the system is driven by the judge. But over the years, in order to address the slow pace of trials, many amendments have been made to the rules of procedure and evidence, incorporating features drawn from the seemingly more efficient civil law inquisitorial system. May I pause to mention, in 2002, I was honored by the Jamaica Bar Association. And when I made a comment to the same effect, describing the civil law system as more efficient than the common law system, I did not have a good reception. So at the tribunal, there is no jury. The judges are triers of both fact and law. I might also mention that on another occasion, I addressed a meeting in Trinidad and Tobago under the auspices of the Caribbean Court of Justice. And I was speaking on the same subject, which is the issue that has grabbed my attention most at the tribunal as somebody from a common law adversarial system. And when I said that there are differences between the 2 systems, somebody from the audience who is a judge and a chief justice from one of the Caribbean countries said, "And long may it remain so," the differences between the 2 systems. Now, admissibility of evidence is based on the more relaxed civil law model, in which professional judges are the arbiters of law and fact. And indeed, pursuant to our rules of procedure, evidence is admissible as long as it is relevant and has probative value. And thus, hearsay evidence is admissible. If admitted, the judges will determine what weight to attach to it. And generally, that is not the case in the common law adversarial system. Again, if you practice law, you could in Jamaica spend half a day litigating whether a particular piece of evidence is hearsay or is not hearsay. But at the tribunal, under the more relaxed system, we take the evidence in as long as it is relevant and is probative. And at the end of the day, you determine what weight to attach to it. Now, the tribunal was right to respond to the criticisms of the slow pace of its work. In practice, the elaboration of the expediting measures has not been easy because the tribunal consists of judges drawn from different legal systems. And almost inevitably, judges tend to bring to the tribunal their legal background. But the tribunal has been able to fashion procedures that meet the standard of fairness required by the International Covenant on Civil and Political Rights, by customary international law, and by jus cogens for the conduct of a criminal trial. As I've indicated elsewhere, in an article that I have written, where there is a conflict between the 2 systems and there is no clearly governing provision in the statute or the rules, resolution must take place using the principle of fairness as the plane to smooth the edges in the alignment of the legal systems. Of the many measures devised by the tribunal to expedite its proceedings, I want to mention just two. In order to address the slow pace of trials, the tribunal has adopted measures, as I've said, drawn from the civil law system, by utilizing written statements in lieu of live testimony in a number of situations. And I'll give one example. In 2000, we adopted a rule under which a written statement may be admitted in lieu of live testimony where the evidence goes to proof of a matter other than the acts or conduct of the accused. And I explain that. In most of the trials before the tribunal, the alleged crimes have not been committed by the accused personally, physically, but by others, example, soldiers or paramilitaries, under the control of the accused. And much of the prosecution case is built on this so-called crime-based evidence, which in some circumstances may be admitted through statements without cross-examination. It is the trial chamber that determines whether cross-examination should take place. Lawyers from the common law adversarial system, of which cross-examination is the cornerstone, might have a thing or two to say about that approach. Cross-examination for them is a procedure for testing the truth, and it has been said that adversarial testing beats and bolts out the truth much better. That's from an American case, Crawford versus Washington. But bear in mind that the evidence in respect of which there is no cross-examination does not go to the acts and conduct of the accused. Now, notwithstanding the introduction of the time-saving measures that I've referred to, criticisms of the pace of the tribunal's trials continued, and the tribunal redoubled its efforts to devise measures to expedite its trials. In 2006, it introduced an amendment that empowered the trial chamber to reduce the number of counts in an indictment and to fix the number of crime sites or incidents in respect of which evidence may be called, while ensuring that the counts and the sites or incidents are reasonably representative of the crimes charged. The representative nature of the crimes is determined on the basis of all the relevant circumstances, including the crimes charged in the indictment, their classification and nature, the places where they are alleged to have been committed, their scale, and the victims of the crime. This provision has had a significant effect on the expeditiousness of trial procedures, because in practice, there has been about a 1/3 reduction in the scope of every indictment. Victim groups have complained bitterly about the reduction of indictments, arguing that it does not do justice to the victims of the conflict. Now, in an ideal world, it would, of course, be preferable to try an individual for each and every crime that allegedly occurred during a conflict. But the ICTY is dealing with criminal trials, not historical archiving. And when mass crimes take place involving thousands of criminal acts and thousands of victims and witnesses, there are limits to how many of those acts can become part of a trial, particularly at the international level. In addition, the tribunals accused are often at the highest level of their civilian or military structures, and therefore of a relatively advanced age, and sometimes in poor health. Trials lasting for many years are simply not a viable option, and so tough choices must be made. All of this only serves to highlight the limitations of international criminal courts and the need for other mechanisms to address post-conflict challenges, such as national trials, truth and reconciliation commissions. I myself served on the Haiti National Truth and Justice Reconciliation Commission and individual complaint procedures to bodies such as the Human Rights Council and similar regional bodies. The tribunal's procedures, both expediting and otherwise, have become a template for international criminal tribunals and hybrid courts. It remains to be seen whether national courts will also be influenced by these procedures. I believe it would be fair to say that the tribunal has spared no effort to ensure that the greater efficiency resulting from these measures has not been achieved at the expense of fairness. Conclusion. There can be little doubt that the tribunal has contributed significantly to the development of international criminal justice. In fact, following the Nuremberg and Tokyo trials, it has, along with its sister tribunal, the ICTY, that's the Rwanda tribunal, been the main contributor to that development. In devising its expediting measures, the tribunal has demonstrated that notwithstanding the differences between the two major legal systems, a procedure that has features drawn from both can achieve fairness in an international criminal trial. The rationale for the establishment of the tribunal was that the trial of persons for the most serious violations of international humanitarian law committed in the territory of the former Yugoslavia would contribute to the restoration and maintenance of international peace. The question is often asked whether that mandate has been discharged by the tribunal. In answering that question, one must bear in mind that the restoration and maintenance of peace in the region is a multifaceted political process, of which the tribunal's judicial work is only a part, albeit an important one. The tribunal has contributed to that process by ensuring that all persons brought before it have been given a fair trial. On a wider level, the tribunal's work has stirred national consciousness of the need to bring to justice the perpetrators of serious breaches of international humanitarian law, and in that respect, it has contributed to the global rule of law. Impunity is no longer the order of the day. The tribunal has shown that impunity can be replaced by a system of accountability that negates retribution and violence. In short, its work has demonstrated that when serious violations of international humanitarian law occur, justice can be achieved through trials of the perpetrators that respect the rights of the accused and are seen to be fair. However, the tribunal's work has also shown that where atrocities occur on a massive scale, as they did in the former Yugoslavia, no system of international criminal justice can ever hope to try all the offenders for all the crimes committed. The fundamental obligation to conduct such trials remains with national jurisdictions. And I want to stress that because this is a strong personal philosophy that I have. International criminal justice should always be seen as a residual measure that is only invoked because of the unwillingness or inability of national jurisdictions to conduct trials. And this is more or less the ICC's complementarity principle, which can fairly be described as one of the most important developments in international law in the post-World War II era. The work of the tribunal has served to emphasize that international human rights law is an integral part of a system of international criminal justice. It has also served to delineate the contours of that system, signposting international humanitarian law, international human rights law, and international criminal law as the pathway to international criminal justice. In sum, ladies and gentlemen, the work of the tribunal has, in its relatively short life of 18 years, become the standard by which a modern system of international criminal justice is measured. Thank you.
For a couple of questions. We do need to end at 1:15, but
I hope this will be two quick questions. Would you dare to venture a date by which the ICTY will have finished? That's one. Secondly, would you comment on how successful the national jurisdictions have been in trying the cases that are coming before it? That's a longer question.
Yes. Well, I'll just give you the timetable. You know that the Security Council established a residual mechanism to carry on the work of the tribunal. That mechanism comes into place for the ICTY next year, June. The Security Council has, in fact, set 2014 as the date when the tribunal should complete its work. So you will see that there will be a period when the tribunal and the residual mechanism will be working at the same time. So that's the best answer that I can give you. And your second question was, what is it?
How effective have the national jurisdictions been in former Yugoslavia in administering justice?
I would answer that by saying that they have been fairly effective. You know that, of course, that in the countries of the former Yugoslavia, you have strong divisions, and it very much depends on who you speak to. But certainly on the basis of the transfer of the cases from the tribunal to those jurisdictions, I would have to say that they have done very well. Now, we have been working with national jurisdictions to help to bring them up to the level where they are perfectly competent to try these cases. And that work is still going on, And I would ask you not to underrate the competence of those national jurisdictions.
Kristen?
Hi, Your Honor. Thank you very much for meeting with us today. I have a quick follow-up question about the residual mechanism, and I was wondering what your opinion is on the residual mechanism, specifically with the case of Rwanda, where not all of the indictees have been arrested. If you can speak to that.
Yes, the residual mechanism, in my view, came about, again, because of the concern about the slow pace of the work of the tribunal and just how expensive it is to have this system of international criminal justice. Therefore, the mechanism has been designed to be as lean and spare as possible. With regard to the indictees who have not been caught, have not been arrested within the jurisdiction of the Rwanda tribunal, I mean, you should know that if they are caught after the Rwanda tribunal has closed its doors, they will be tried by the residual mechanism, because the mechanism, which will be comprised of judges, many of whom will be judges of the two tribunals will have a trial jurisdiction and an appellate jurisdiction.
We have time for maybe one more question. Quick, Elias.
Again, thanks a lot for coming. Just a quick question. You mentioned that the Rome Statute was drafted in a relatively short amount of time.
No, not the Rome Statute as it is now. What I was speaking about was the assignment that was given to the International Law Commission in about 1992 to do a draft of an international criminal court. And that draft, the ILC did. I was a member of the working group, very, very quickly. But the Rome Statute, of course, I mean, once the preparatory commission started working, took probably about 6, 7, 8 years. So as I read it, I realized that I might not have been sufficiently clear.
Yeah, I'm sorry. I think the question relates specifically to that point anyway. So given the short amount of time that this document was drafted in, I was wondering, given the disagreement and wide disagreement in different conceptions of state sovereignty and individual rights all around the world, I wanted to get your take on whether you thought that this was an exercise in politics by the few powerful countries that drafted that initial document, or did that document reflect a wider consensus in general principles of international criminal law?
Well, in the first place, I believe that, about 6 years for the drafting of the statute is long enough. And I say this as somebody who participated in the United Nations Conference on the Law of the Sea, which, as you know, was very long-lasting. Well, the drafting of international treaties and conventions is always a policy-political process. And you will always have power politics at play. Now, I am not prepared to say that in the Rome Statute, power politics was more at play than it was in any other, in the drafting of any other international convention. But of course, yes, the politics was there. Well, to begin with, the superpower, the United States, is not a party to the Rome Statute. So that itself will tell quite a tale,
So I think we're unfortunately out of time. There's another class that needs to come in here. But if you do have questions for Judge Robinson, we'll be around for a little while now, and also at the reception this afternoon at 4 o'clock. So please join me again in thanking him.
Produced by Duke University. Online at duke.edu.